You've written quite a bit and talked quite a bit very recently, Judge, about the January 6th investigation, about the so-called insurrection at the Capitol. Give us a quick overview of your current thinking.
Well, there's a couple of lanes of thinking here. One is that the government has treated what was intended to be ordinary, legitimate, absolutely First Amendment protected protest as if it were a crime. There no doubt were some crimes committed. There was some trespass into areas not permitted, and there was some destruction of property. But the overwhelming majority of people who were there were welcomed by the security guards and were there to express a political opinion. Whether the DOJ agrees with that political opinion or not is irrelevant. The DOJ has taken an oath to uphold the Constitution, which protects the expression of all political opinions. That's lane number one. Lane number two, Roger, is that many of these people have been radically overcharged. That is, charged with crimes for which the punishment will wreck their lives for the next 10 to 20 years in an effort to terrify them into pleading guilty to a lesser included offense because the government simply doesn't want to try these cases. The principal reason the government doesn't want to try them is the government will be humiliated and embarrassed when the behavior of its own agents, undercover and not undercover, is made known to a jury. The third lane here is the absolutely awful, despicable, unlawful, unconstitutional American gulag-like treatment of individuals who have been arrested and given no bail, who've already served more time in jail than they could possibly serve, even if they're convicted of these crimes, and the treatment that they've received at the hands of the jailers and at the hands of fellow prisoners. Excuse me, all of this could be stopped with a phone call by Merrick Garland, but he's not interested in upholding constitutional rights. He's interested in suppressing dissent. So those are the three profound areas, if you will, that will require exploration. I don't know if they're going to have happy outcomes. I know that history will treat the Biden administration very harshly on these areas.
Judge, are you concerned about the lack of due process involved? In other words, in a number of these cases, I'm told that in discovery, documents are being denied to defendants, videos are being denied to them. In some cases, videos that are given to other defendants, when compared by lawyers to a different defendant, show that the videos may have been edited. It seems to me that there's a very substantial due process issue here.
That's a profound due process issue. It's called a Brady violation. Brady's the name of the case that requires the government to share its files, its unadulterated files, with defense counsel. It can often result in the disbarment of the prosecutors. Occasionally, as in the case of the late Senator Ted Stevens of Alaska, it can actually result in the prosecution of the prosecutors. We know this is going on for the very reason you articulated. So defendant A asks for documents and he gets half of what he thinks he should get. Defendant B asks for his documents. He gets documents that show that what A got were adulterated, were cut, were edited. That's absolutely not permitted. The courts should not permit it. The lawyers should be crying foul because it's a profound violation of due process. Due process means a fair procedure before a neutral jurist and a neutral jury. You can't expect the government to be fair. The government is never fair, but you can expect the government to obey the laws it is sworn to uphold. And among those laws is Brady, which requires that the government share its files with the defendant. The government must produce everything that hurts its own case and that helps the defendant. The government doesn't have to produce its own notes and its own impressions, but it has to produce everything else.